have our courts been confronted by so polemical, elastic, and indeterminate notion as the so-called basic structure doctrine. And it all began with when a group of distinguished citizens, aggrieved by what they perceived was an imminent overthrow of the Constitution, approached the court, the High Court in particular, seeking its intervention to stop that overthrow. And I've also, like my colleagues, traced the origin of now what is being called the basic structure doctrine. And I don't think I need to go into the stages, the historical stages of how this notion, in my view, sprouted and continues sprouting in parts of the world. I think that my colleagues who have spoken have done a sterling job, and I do not intend to retrace the history of this doctrine. But I do ask, how did we find ourselves enmeshed in this kind of theorizing? Because right from the High Court and now up to this court, what we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of a court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? It's because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court. The petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination, even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has snowballed into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thought, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best a heuristic device which a court of law, when faced with the question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. And indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. But to begin by seeking a declaration there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry, first through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on, that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, There is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative. So that leads me to the next issue, whether the president can initiate changes or amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through the parliamentary initiative. In agreement with my colleagues at the High Court and Court of Appeal, I am of a firm opinion, having read the relevant provisions regarding that issue, and in context, of the opinion that a president cannot initiate what is referred to as a popular initiative under Article 255 and Article 257 of the Constitution, because those articles talk about an initiative to amend the Constitution by the people. And the word people here is not an ornamental one. It is a serious expression of what forms what we consider a social contract. And both the High Court and Court of Appeal held that such an initiative is reserved for what they call the common mwananchi. But before answering this question, I had to ask myself as to what really constitutes a popular initiative. In my view, a proposal to amend the Constitution through a popular initiative comes into being when there is a felt need for such an amendment by the people. But care must be, however, taken, as advised by Professor Migai Akech in his amicus brief, not to anjikunize, no, but that's my expression, not to anjikunize every stage of constitution making or amendment. In his comprehensive analysis of the history of the constitution making in Kenya, the good professor, rightly in my opinion, decries the tendency to underestimate the role played by what he calls the political elite in the making of the Constitution of 2010. And why do I agree with him? Because, in my view, a democratic polity such as ours comprises of a complex mix of the ordinary, the elite, and the philosopher, each of whom is entitled to meaningfully participate in the popular initiative of constitutional amendment. Therefore, this felt need to amend the Constitution may find expression in various fora, such as our institutions of higher learning, public symposia organized by civil society, religious and community-based organizations, if you remember the Ufungamano caucuses, and even public rallies, as long as those rallies are not organized under the influence of the political class, especially the elected one. These symposia and caucuses and rallies would have as their main objective the need to firstly clarify the rationale and content of the proposal for amendment, and secondly to sensitize the general public and harness their support for such a proposal. At the end of the day, this felt need will have undergone such repetition, such notoriety, such refinement, and would have acquired such stability and coherence as to be capable of being formulated into a general suggestion or bill as stipulated in Article 2572 of the Constitution. At no stage, is very clear to me, is the role of the president, qua president, contemplated by the provisions of that article. It cannot have been lost on a casual observer of our painful history that it was the imperial presidency that mutilated the independence constitution through unchecked amendments to such an extent that at the end of the day, this country had lost any pretensions to democracy, rule of law, human rights, or social justice. And by the early 1990s, the Kenyan people were terrified, tormented, and dehumanized a lot, deprived of any sense of self-actualization in the manner in which they were governed. It was from such despondency that the people would rise to demand a new social contract, a new order that would not only restore their dignity, but also prevent the executive arm of government, if you like, read the president, and to a certain extent the legislature, from reversing the new equilibrium, from taking them from the paradigm shift to which they had cutted themselves. And so to this question, I have no hesitation in holding that the president cannot initiate a popular initiative. That takes me quite quickly as to whether indeed the president did initiate this popular initiative. It's on record, Vide Gazette notice number 514 dated 24th May 2018, that the president appointed a task force named Building Bridges to a United Kenya Task Force, or the BBI task force, if you like. This task force was composed of eminent Kenyans whose mandate it was to address the 9 key challenges facing the country. And these challenges have been identified in a memo of understanding signed between the President and Right Honorable Raila Odinga. Thereafter, the President, Vide Gazette Notice number 264, published on 10th January 2020, appointed a steering committee on the implementation of the Building Bridges to United Kenya Task Force report. One of the terms of reference of that steering committee was to propose administrative, policy, statutory, and constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report. It is out of which the steering committee that we now have the Constitution of Kenya Amendment Bill of 2020. I, on my part, find, although the High Court later described the task force as an unconstitutional outfit, I, on my part, find that there was nothing unconstitutional in the appointment or composition of either the task force or the steering committee by the President. What remains is whether the President can be regarded as having initiated the process that culminated into the bill that we now have. And in conclusion, I have stated that taking everything into consideration, all the stages, all the processes that led to the bill, I find it difficult to distance the President from the involvement and the initiation of the popular initiative. Therefore, I find that the President did actually originate this initiative. The conclusion deriving from this, I shall return to in my final conclusions. And now, next is whether the second schedule to the Constitution Amendment Bill 2020 is unconstitutional. Both the High Court and Court of Appeal found that schedule unconstitutional. I have considered the reasoning by the two superior courts, I have looked at the relevant law, and I come to a similar conclusion that this second schedule to the Constitution of Kenya, Amendment Bill 2010-2020, is actually unconstitutional. Fourth, I consider whether civil proceedings can be instituted against the president in person or a person performing the functions of the office of the president during his tenure of office. And I know I've taken into cognizance the submissions by the Attorney General urging the court to find that such proceedings cannot be instituted against the president or a person performing the functions of that office. I also know that there are those who have strenuously opposed the Attorney General's submissions and have argued that such immunity is limited, so limited that the president can on occasion be sued where or if he violates the Constitution and if he violates any other law when he is not acting in his capacity as the president. And having carefully considered those arguments, I find considerable difficulty in appreciating the rationale or basis upon which first the High Court found that notwithstanding the clear and unambiguous language in Article 1432 of the Constitution, that the President can still be sued in his personal capacity for acts or omissions alleged to be in violation of the Constitution. Why did the High Court introduce the phrase "only protected"? And then turning to the finding by the Court of Appeal, I find similar difficulty because it is clear that should the President engage in an act or omission that is violative of the Constitution, there are constitutionally recognized pathways through which such violation can be put right. And I have mentioned and discussed them in the body of my judgment. But a more profound legal reason for presidential immunity in both his private and official capacity is to be found in Article 1433 of the Constitution, which provides that where provision is made in law limiting the time within which proceedings under Clause 1 or 2 may be brought against a person, a period of time during which the person holds or performs the functions of the president shall not be taken into account in calculating the period of time prescribed by that law. And what is this law referring to? It must be referring to the law of limitations. And then why would the president be denied the benefit of limitation of actions? Precisely because the president cannot be sued in his private capacity during the tenure of his or her office. And I also state that once a president, always a president until he or she vacates the office, because you cannot be a president today and tomorrow you are not a president, so that you may be so sued. That brings me to issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC and whether there was public participation. And in response to this, after serious analysis, I find that there was no obligation on the part of the IBC at the time it embarked upon the verification of signatures to satisfy itself as to whether there had been public participation before the bill and signatures were transmitted to it. I do not find anything in the Constitution that obliges the IBC to carry out that function. But what about the promoters of the popular initiatives? What about Dennis Waweru, Mr. Waweru, Honorable Junet who have defined themselves as promoters? Were they not supposed to undertake meaningful public participation? The argument that I see here against such a proposal is that the process of popular initiative begins with the collection of signatures. And I do not agree with that proposition, because before you collect signatures, there must be something you are offering the people. You are taking to the people either that general suggestion or a draft bill. And if you are seeking their signatures, surely the people must understand the contents of the bill to which they are appending their signatures. I have read the contents of the affidavit sworn by Honorable Waweru, the contents of which state that there was a comprehensive and robust process of consultation. But the contents of that robust consultation are not clearly stated. And so I'm concluding that when it comes to the promoters of the popular initiative, I do not myself think that they undertook sufficient or meaningful public participation under within the meaning of Article 10 of the Constitution of 2010. And now this brings me to the interpretation of Articles 88 and 250 of the Constitution with respect to the composition and quorum of the IEBC. This one has been thrust to us because somewhere along the line, the petitioners did allege that at the time it undertook the verification of signatures, the IEBC lacked the requisite quorum to be able to constitutionally undertake that task. And then I have also looked at the history of the legislative form that prescribes the quorum of IEBC. I've looked at the contents of the Article 251 of the Constitution, and I come to this conclusion that if, as indeed we must conclude, that at the time the IEBC undertook the verification of signatures, it was constitutionally and properly so constituted, how on earth can we then say that it lacked quorum to undertake the tasks for which it was properly constituted? And then my attention has been drawn to the contents of paragraph 5 of Schedule 12, I think, to the IEBC Act, which sets that quorum at 5. And I'm simply saying that as between a constitutional provision, you cannot use the provisions of a statute to override the majesty of a constitutional provision. And having so said, I find that the IEBC had the requisite quorum to conduct the verification of signatures and any other task that the Constitution requires it to undertake. And finally, I come to this vexed question of whether the interpretation of 25710 of the Constitution entails that all, or requires, that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions. I had no difficulty in disposing of this particular issue because it was not ripe, as rightly observed by my colleague Tuyot J.A. of the Supreme Court. And I'm not the kind of person to engage in abstract exercises. Because if we did that, then we would be also encouraging Kenyans, as indeed they have done to us in this basic structure imbroglio, to come with abstract questions and expect us to expend valuable judicial time disentangling the same. So what are my conclusions? One, the basic structure doctrine is not applicable in Kenya in the way and manner in which it has been formulated, because it's no such doctrine, neither does it have a force of law juridically so understood. I've said it is a heuristic device. The four sequential steps of civic education, public participation, and the rest are not also applicable to the process of constitutional amendment envisaged under Articles 255, 256, and 257. Such steps, and not necessarily in that order, would become operative in the event of a seismic constitutional moment, which dictates that the people must exercise their primary constituent power to make a new constitution or re-establish the constitutional order. And 3, the president cannot initiate or activate any constitutional changes through a popular initiative process as envisaged under Articles 255 and 257 of the Constitution. 4, the president actually did initiate the proposed constitutional amendments, and the effect of that, I believe, should be able to come out in the final disposition of this dispute by this court. The second schedule to the Constitution of Kenya, Amendment Bill 2020, is unconstitutional. Civil proceedings cannot be brought or instituted in any court of law against the president or a person performing the functions of that office in their personal capacity during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. And 7, the IEBC is not under any obligation to ensure that the promoters of a popular initiative have facilitated public participation before transmitting the resultant bill to it. But I also say that in this particular instance, no meaningful public participation was conducted by the promoters of this bill. 9, the IEBC had the requisite quorum at the time it undertook and completed the verification of signatures. And finally, the interpretation of Article 257.10 in the manner in which the issue has been formulated is not ripe for consideration, not just by this court, by any other court in this country. Before I sign off, my mind races back to those 3 days in this tent during which I and my colleagues here sat patiently, pensively, and attentively, listening to the impassioned pleas from the bar so commandingly assembled. Not that this was the first time I was finding myself having to endure the perorations of counsel. Some of them experienced jurists and others not so senior. But it was such a moment when the basics of a basic structure were basically spewed unto us with such aplomb hitherto unseen, save during the hearing of a presidential election petition. What we were told, however, I also remember that it was on such occasion that we were reminded that our colleagues at the High Court and Court of Appeal, the colleagues at the High Court had built a foundation, and those ones at the Court of Appeal had constructed a wall upon it, and that now it was our turn to paint that wall. But we were not told with which colors we were to undertake this alluring task. I also remember being urged to roar like lions in the wild as we asserted the supremacy of the Constitution. But who could fault counsel for invoking our hallowed symbol of nationhood? Yet at that moment I could not help but cringe, for the sound of a roar of a lion in the wild stirred in me images of the terrifying language so beloved by our politicians, the language of tsunamis, of earthquakes, volcanoes, war, and thunder. And that is why I cringed. And then I remembered that not so long ago, this court had in one of its judgments, and really in true oracular rendition, or so I thought, decreed as follows. But it does appear, as my colleague Judge Lenaola here apprehended, counsel do not read the judgments of this court. And now I am forced to read this decree to you so that even if you don't read it, it shall be acted in your mind. And this is what this court said at that time. What of the argument that this court should not subvert the will of the people? This court is one of those to whom that sovereign power has been delegated under Article 13C of the same Constitution. All its powers, including that of invalidating the presidential election, is not self-given nor forcefully taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular that invitation may seem. Therefore, however burdensome, let the majesty of the Constitution reverberate across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the trees. Let it sprout from our institutions of learning. Let it toll from our sanctums of prayer. And to those who bear the responsibility of leadership, let it be a constant irritant. So I say no more. Thank you, Chief Justice.
Thank you very much, Justice Wanjara, for that rendition. I now request the Honorable Mr. Justice Ibrahim Mohammed to deliver his opinion.
Thank you very much, Honorable CJ, the President of the Supreme Court of Kenya. Every judicial officer or judge has his style of delivery, but when there is a pressure of time, you elect how to do it, considering the question of time also. The art of brevity does not come or are not bestowed on everyone. So you might find that I may take a bit longer on some issues, but to save time also, I may summarize. I may give a summary of my findings in some of the issues and also the dispositions on each issue, while in others I may give some more elaborate explanation for my conclusion and disposition. The Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Lady Justice Martha Koome, has in the lead judgment aptly captured the history and background of the appeals before us. She has also pertinently set out the written and oral submissions by all counsel, as well as the embassy, for which I thank her on our behalf. I see no need to replicate or rehash the same. I've referred to the 7 issues which were framed by the court on the 9th of November 2021. The 7 issues, I'll not read them out. Thank you. I'll not read them out as they are already on record and have been referred to by all my colleagues. I'll also refer to them one after the other. I find myself substantially in agreement with the arguments and conclusions by the Honorable Chief Justice Koome, President of the Court, on some issues. Just as well, on some, I'm of divergent views. I render my opinions and pronouncements on the issues as delineated by the court. The first question is regarding the basic structure, whether it's applicable in Kenya and if so, the extent of its application, whether the basic structures of the Constitution can only be altered through the primary constitution power, and what constitutes the primary power. In answering and determining these questions, I trace the history of what is the basic structure and what it comprises of in the framework of a constitution. I trace that history globally from the Federal Republic of Germany to India, the US, France, then also to the other countries like Malaysia, Singapore, Bangladesh, Uganda, and many more. Some of these states, particularly the ones which came to consider later the basic structure, some were disinclined initially. That's the courts in those countries, but later some of them adopted and accepted the said doctrine. I finally came to the applicability of the said doctrine of basic structure to Kenya. I followed our journey of constitutional making from the CKRC to the Bomas Conference. During the said process, Justice Ringera, as he then was, grappled with the question of the basic structure of our repeal constitution. He concurred with the majority pronouncement in the case of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. This was in the case of Timothy Njoya and others versus CKRC and another. The application of the doctrine also arose in the case of Patrick Ouma Onyango and 12 others versus AG 2008. The court, consisting of Justice Nyamo, Wendo, and Mkule, found and declared that the basic steps in constitutional making, they declared the basic steps in the constitutional making. Then there was the case of Commission for the Implementation of the Constitution versus National Assembly of Kenya, 2013, where Honorable Justice Lenaola, as he then was, analyzed the question of the basic structure of the Constitution, although that was not really a direct issue, and also the issue of its applicability was not before the court. I just want to refer that it was considered and it was a known principle before this case, which is before us. Then there was a case of Priscilla Ndululu Kivuitu and another versus AG 2015, wherein the three-judge bench, Korir, Mumbi, Ngugi, and Odunga, held that some amendments under Article 255, or Article 257 can only be done with the involvement of the citizens by way of referendum. They relied on the sentiments expressed by Honorable Ringera J. in the Njoya case. The three judges, I'll refer to paragraph to what they said. I'll go directly to that, what they said. They say that we agree with the sentiments expressed by Ringera J. in Njoya 2 that an amendment that upsets the basic structure of the Constitution could not be effected by Parliament without involving of the people. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in the Njoya 2 case was necessary. This may explain why the people of Kenya, aware of the frequent and frivolous amendments to the repealed Constitution provided in Articles 255 of the 2010 Constitution, and I refer to the contents of Article 255, where strict conditions were given before any amendments could be carried out. And I don't have to refer to that. It is clear from the above cited provision that there are amendments that can only be done with the involvement of the citizens by way of a referendum of Article 255(1) or popular initiative involving at least 1 million registered voters, Article 257(1). So it means that the judges themselves in this case, referring to the basic structure, identified Article 255 as containing principles of basic structure. Even where Parliament has been mandated to amend the Constitution, it can only do so after the amendment bill has been subjected to public discussion, Article 256(2). The voice of the people is a voice that cannot be ignored when it comes to the amendment of the 2010 Constitution. We wonder, and they continue, we wonder whether in light of the provisions in 2010 Constitution, the proposition that Parliament cannot amend the Constitution in a manner that may result in the distortion of the basic structure, again they use the word basic structure, still has a place in our jurisprudence. However, this is not an issue that has been taken up with us, and we will say no more about it. So I'm just giving the background that these issues have been before the court, but not directly. But now, in our case, it is directly before us, and we have to deal with it. There's been a discussion and contestation of whether this basic structure is a doctrine or even a principle. An uncontentious example of popular doctrine, for instance, is that of the separation of powers in a tripartite form of separation comprising the executive, judiciary, and legislative arms of government. We credit the French jurist with a long name, Charles Louis de Secondant, Baron de la Brede de Montesquieu. I'm not very good in French, or in fact, I don't know French at all. Or Montesquieu, I read him in history, simply referred to as Montesquieu, as the father of the doctrine. This doctrine is embedded in our legal system by direct reference in various, and we have adopted it even in the structure of our Constitution. However, even as we make reference to the doctrine of separation of powers today, it is not to say that the doctrine has not evolved since 1748, or that it is only Montesquieu who discussed it. In Kenya, we have not only laws, however, that incorporation was with some modification to suit our peculiar circumstances, such as the addition to the independent commissions and offices. Yet in doing so, we have not explicitly provided for it, or even defined the doctrine of separation of powers in our laws. Still, it is evident that we have applied it. So the question of the basic structure as a doctrine, what is it? What does it encompass? Is it applicable in Kenya? This is the duty we have, and we cannot just dismiss this. Many times it has been said that this doctrine of basic structure, the origin came from the case of Kesavananda, 1973, whereby the majority of 7-6, the court in India, Supreme Court, held that the Article 368 of the Indian Constitution does not enable Parliament to alter the basic structure or framework of the Constitution. And there's a quotation or citation by two judges, Justice Hedge and Justice Mukherjee. But after tracing the history, we find that actually these principles did not emanate from India. It emanated from the scholar, a colleague referred to that, the scholar called, there's a Professor Conrad of Germany. He gave us a talk in some Indian university, and this idea was captured or was captured by some lecturers and some professors, and finally it reached the ears of some judges who, in the case of Golaknath versus State of Punjab, 1647, who applied those principles, and that was the first foothold in India, that case of Golaknath. Even though the court then did not accept any limitations on Parliament's power to amend the Constitution. So, regarding the Germans, it's not easy to see why a German jurist would propagate implied limits to amending the constitutional powers. Article 79.3 of the Basic Law of the Federal Republic of Germany, adopted on 8th of May 1949, explicitly bars amendments to provisions concerning the federal structure and to basic principles laid down in Articles 1 and 20 on human rights and democratic and social setup. The Germans were healing from the Nazi era, and it is for that reason that the framers of the Basic Law sought to create a constitution that would safeguard against the emergence of either the Weimar Republic's overly fragmented multi-party democracy or the Third Reich's authoritarianism. And there have been arguments in various cases in support of this. Now, in France, the same thing happened, where a scholar called Schmidt was, where a scholar called Maurice Hariot, a professor of administrative law and constitutional law, published 2 constitutional treatises, and the difficult name it has, I can't read it, setting out the history of implied limits on constitutional amendment. Now, coming back to, I'm referring now how this has been discussed in Kenya. Yaniv Rosner, in his article on constitutional amendments, the migration and success of a constitutional idea, in the American Journal of Comparative Law, drew attention to the debate of the first American Congress, more particularly the debate that took place on August 1789. So there's a lot of discussion in the US, and I don't have to go to the cases. Everything is in that judgment. I've gone rather into some detail. Legal doctrines and principles are often traceable to a particular school of thought, and more specifically to a certain scholars who sought to elaborate them. The importance of this is to address the contestation regarding whether the basic structure doctrine was a creature of judicial craft, or even whether the courts are capable of creating doctrines. This is not to make a case for incorporation, or rather reading into our laws. All doctrines and legal principles are in existence. From this, however, it is evident that the doctrine of basic structure was not invented by the judiciary in India and some of the other countries. It has been submitted that the doctrine of basic structure has yet to gain universal experience. And for that reason, we are asked to find that it is not applicable. I do not think it is necessary that before application of a doctrine or legal principle, the same must have universal application. I say this because not all legal doctrines and principles are universally applicable due to the differences in legal systems, such as the civil and common law. This is also because of our unique peculiarities, such as states due to our historical, cultural, and social systems. My thoughts on this are further fortified by our Constitution, read together with the Judicature Act, Cap 6, laws of Kenya, which allow us to apply the doctrine that are in line with our laws, more so if they assist us better to interpret and apply them. So there's a lot of reading material which I've referred to. So directly is the doctrine. Is the doctrine of basic structure applicable to Kenya? The basic structure doctrine is not only new to is not entirely new to our jurisdiction. Much like the other countries, Kenya has had opportunity to grapple with the doctrine of basic structure in our circumstances. During our journey of constitutional making, we had the CKRC appointed in November 2000. The commission chaired by Professor Yash Palgai convened the National Constitutional Conference for discussion, debate, amendment, and adoption of its report and draft bill, famously dubbed the Bomas Conference, due to taking place, which was taking place at the Bomas. The Bomas Conference was convened and adjourned 3 times, out of which a draft was amended and adopted by the acclamation by the conference, sitting in plenary on 23rd March 2003, then handed over the constitution to the Kenya Review Commission. However, before the conference was adjourned, there was a number of challenges to the validity or legitimacy of the entire constitutional review process and its outcome, one of which was the case that I've referred to, Timothy Njoya and others versus CKRC. The applicants sought inter alia, that was 2004. The applicants sought inter alia a declaration that certain provisions of the Constitutional Review Act transferred, diluted, and vitiated the constitutional power of the people of Kenya to adopt a new constitution. The court held that the new constitution needed to be ratified through a national referendum, as the right to a referendum was a fundamental right of the people in exercise of their constitutional power. Ringera J., who is now retired, who was in the majority, concurred with the pronouncements of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. And there's a citation here, which I don't have to go through, where Justice Ringera, and which means our courts, recognized the principle of, this is my submission, principle of basic structure. Application of the doctrine again arose in the case I referred to, Patrick Ouma Onyango. One of the issues that arose was whether Parliament, in its limited delegated role, had the power to debate, alter, or amend the Bomas draft constitution, which was the product of the view of the people. It was also questioned whether that interference by Parliament had the effect of elevating the members of National Assembly above the people of Kenya as sovereigns. The court, consisting of Nyamo, Wendo, and Mkule, held, and I think I should refer to it very quickly. We further find and declare that what will give purity to the process is the enactment of the proposals as a constitution by the people in the referendum. It is the enactment by the people which gives purity and validity. Yes, they are the touchstone of validity, the people. The applicants in their final written submissions did concede that constitutional power cannot be restrained. We exercise judicial power on behalf of the people, and we cannot restrain for them in making their choice. These are 3 judges of our courts speaking for the people of Kenya. We find and declare that the basic steps in constitution making are 1, popular consultations, 2, framing of the proposals, 3, referendums or constitutional assembly elected and mandated. We find the challenge process has satisfied all the 3 steps. We find and declare that the process is not flawed. In our view, the real judges of the process are the people of Kenya, in view of the past involvement with the process as outlined. I'm not going to go through all that. There's a lot of material which I will let you read when you get this judgment. Basically, it is to show that Kenya itself, due to the 2010, people discussed in depth the history and the problems that Kenya went through, the hyper amendments that we had gone through, and the result was the 2010 Constitution, and in particular Chapter 16 and Articles 255, 256, 257, which I will be persuading you in this opinion that contains the basic structure that supposed to protect the people from amendments by even the delegated power, which is Parliament. After the promulgation of the Constitution in August 2010, there was a case of the Commission for the Implementation of the Constitution versus National Assembly of Kenya, where the National Assembly, by the Constitutional Amendment Bill 2013, sought to amend Article 260 of the Constitution in respect of the definition of state office. I'd already discussed that. Then there was the case of Priscilla Kivuitu. Then we have various cases. Attorney General versus Randu Nzai, whereby the court held that in view of the foregoing, the appellant's contention that the respondent's agenda of succession is unconstitutional has no basis in law. The respondents have a constitutional right to demand succession, but that can only be done within the confines of the Constitution as stipulated under Articles 255, 256, and 257 of the Constitution. Now, in all these cases, the applicability of the basic structure doctrine was not a substantive question of the courts. The courts were asked to determine, unlike the present one. So, in this case, through my proposals here, which I don't wish to go through, and I have told you the art of brevity is not donated to everybody, and I'm not one of them. So I'll let you read. But I'd refer to what I've said here. That there was this decision by Justice Mativo in the Third Alliance case, Kenya versus another versus Head of Public Service, Joseph Kinyua, and others versus Martin Kimani and others. In that case, Justice Mativo said, he referred to this doctrine and stated as follows: the command in Article 259 is instrumental in shaping the constitutional jurisprudence in this country. Call it by any name, basic structure, or whatever, but Article 259 provides the manner in which the Constitution is to be interpreted to maintain its fabric, which cannot be dismantled by any authority created by the Constitution itself, be it the Parliament, the Executive, or the Judiciary. Couched in this doctrine are a few crucial aspects. First, that constitutions are considered to be the act of the people as the almighty sovereign. We see this as the power of the people recognized and documented in the preamble of our Constitution, which begins as follows, and I quote, "We, the people of Kenya, exercising our sovereign and inalienable right to determine form of government of our country and having participated fully in the making of the Constitution." So I've gone through this and I invited you, as some of my colleagues have said, some of our judgments are long. Mine is 125, and I would not wish to read through it. I invite you to read carefully, but after going through all my arguments and citing various cases and showing the historical road we passed to acquire, to get this very important Constitution 2010, of which I'm sure all of us are proud of and all of us cherish, I came to the conclusion, my disposition on this issue first issue, noting our history, context, and constitutional text, I find that the doctrine of basic structure is applicable to Kenya. Further, that the basic structure of a constitution can only be altered or denatured through the primary constituent power. C, it's my further finding that the primary constitutional power is the unbound power of the people to make or unmake constitution, and genuine exercise of the same can be identified by the 4 sequential steps of civic education, public participation, constitution assembly, plus referendum. So I've set out in the judgment what the basic structure entails. And I've set out and I've discussed the issue, where, can the basic structure of the Constitution only be altered through primary constitutional power, and what constitutes the primary power? I've discussed that, and that was my dispensation. So that is my dispensation in that question, and I invite you to read that. So in the interest of brevity of time, I'll go to another issue. Issue number 2. Issue number 2, whether the President can initiate changes, amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through a parliamentary initiative under the Article 256 of the Constitution, or through a popular initiative under the Article 257 of the Constitution. I'll give a summarized view of this, which is contained in this opinion and judgment, and also one more issue. The other issue is the place of public, issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC. The other 3, I wish just to set out and read and state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatembu J.A. rightly observed that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitution amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constituent power of the people. The Commission, in addressing the issue, recommended that that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifi Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and Amendments to the Constitution held up to the creation of 2010 Constitution, the report said, a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only own motion by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. 2-year JA went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated, and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups. Regarding the assertion that the President can initiate process of constitutional amendment by way of popular initiative in his capacity as a private citizen, two pertinent issues arise. First is the fact that Article 257.5 subscribes the President a role in the amendment process. Article 257.5 provides that if a bill to amend the Constitution proposes an amendment relating to matters under Article 255, the President shall, before assenting to the bill, request IEBC to conduct a national referendum within 90 days. The import of this provision is it assigns the President the power to decide whether or not to hold a referendum. To ensure the integrity of the process of constitutional amendment pursuant to Article 257, we cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he is also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest. This would be detrimental to the interests of the people and the nation. Second is that the President ceases to be an ordinary citizen the minute he takes office. Article 131 describes him as the head of state and government, who exercises executive authority of the Republic. He is also the Commander-in-Chief of the Defense Kenya Forces. He chairs the National Security Council pursuant to Article 240, which exercises supervisory control over national security organs, including the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. He is also the symbol of national unity. He plays the various powerful roles pursuant to Article 132, including appointing Cabinet Secretaries, Attorney General, Principal Secretaries, High Commissioners, Ambassadors, as well as diplomatic and consular representatives. He is empowered by virtue of Articles 132, 4D and E to declare a state of emergency or declare war, respectively. He may also, pursuant to Article 192, even suspend county governments, either in emergency arising out of internal conflict or war, for any other exceptional circumstances. By virtue of holding this office, the President is accorded immunity with Article 143. So you can see the special position of the President. And we are saying, and I'm saying that the President cannot act as a promoter or initiator, even if you have to use that name, initiator, he cannot commence or get involved. In this particular case, there is evidence that not only did he start the process, but he was also involved throughout, and all steps taken by others the genesis was his own actions through the Gazette notice and the legal steps that he took. This power and control that the President exercises by virtue of his position was evident in the inception of the amendment bill, as rightly pointed out by the learned judges of the superior courts. Right from the handshake that was between him as the elected president following the contentious 2017 general elections and rerun, and his competitor and challenger, Honorable Raila Odinga. He then proceeded to appoint that. So I gave, in this narration, I give the history of all the steps and that he was involved in directly. building bridges to a united Kenya, from a nation of blood ties to a nation of ideals. The appointment of the teams, the Gazette notices throughout. The first step had a domino effect, and throughout he was involved, and the government's role was also very clear. The difference in the amendment bill that was launched on 25th November 2020 from the amendment bill contained in the BBI Steering Committee report presented to the President on 26, 2020 are better contextualized in discussing the place of public participation under issue number 5. My conclusion there is that on whether the President can initiate a popular initiative to amend the Constitution under Article 257, it is my finding that he cannot. Issue number 3, on whether the second schedule to the Constitution of Kenya Amendment Bill 2020 was unconstitutional, I find that on issue number 3, I find that the second schedule of the Constitution of Kenya Amendment Bill to have been unconstitutional. On question number 4, it is my finding that pursuant to Article 143(2), no civil proceedings can be instituted against the President or person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution.